my career. We pounded. The staff would get wild because we'd be running over the time, and they had other obligations. It was just a tremendous feat by 3 judges who were trying to administer justice in the fairest way they could. I've had occasion to read Judge Hanlon's writing. I don't need to comment on her academic credentials or her writing skills, or her judicial ability, but especially, which might not come through on such a serious hearing, is her wonderful sense of humor. It was a joy at lunchtime. We didn't always discuss cases. We had a lot of fun at that lunchtime, and we'd divert ourselves with nonsense to take a break from the burden of processing all that work. City was also blessed with great staff in probation, a great security staff. We have 75 to 125 prisoners in a day that we had to get through there, in addition to the usual people that you want to get in and out as fast as you can. And she handled that with great skill. And the clerk's office, you have to appreciate in the clerk's office, you have to wait for the police to come in to get their reports, to type up their complaints, and then the clerk's office, and then the probation department has to come down to the lockup and interview these people. And then at night you have to have clerks there who will be willing to type up writs and days for the following day. I mean, it was just unbelievable. And she did it with great spirit and great commitment. And she encouraged judges, such as myself and Roz, to become involved. I was involved in that Changing Lives Through Literature program, which I loved all the time I served in Dorchester. Her focus was, how do we divert people from coming back? How do we reduce the rate of recidivism? And it was with that attitude that she would jump in with 30, would come up with an idea like the fatherhood program. And I did that too. I mean, I have 6 kids. I have 9 grandchildren. I would leave any one of my grandchildren in the care of City Hanlon. I can't give anyone a higher compliment than that. She is going to be so wonderful at the appeals court, because she will bring that street savvy that she has developed by working in one of these busiest courts to some of the judges who have been more removed. And she is going to elevate their ballgame. There's an old joke about the members of the appellate court. They're like generals who, after the battle has been fought, come down and shoot the wounded. I don't think. Sorry, James. You've heard it.
Not, but that's interesting.
In any event, it's my every expectation that she is going to elevate everybody involved in it. And I commend her to you with enthusiasm and without any reservations at all. Thank you.
Thank you very much, sir. That concluding the list of people in support of your nomination. At this point, we'll hear from the folks. We have a list here of the people who would like to speak in opposition. And first, we'll hear from Patrick McCabe. And if I could ask for the folks who would like to speak in opposition, obviously we'll give you as much time as you need. But if you could limit your comments to your experience with Judge Hanlon, we would appreciate that. Thank you very much, sir.
My name is Patrick McCabe. I'm not a lawyer. I have never been in court, to my recollection, with Judge Hanlon, although I have served doing my jury duty in Dorchester Court on more than one occasion. My experience with Judge Hanlon comes from a panel meeting last year at the New England School of Law panel was about domestic violence, and Judge Hanlon was one of the 6 or 7 panelists. As the panel discussion went on, there were many people on the panel who were very critical of the current state of domestic violence laws in Massachusetts. And they presented their case, and the lawyers and students and other representatives on the panel each presented their opinion, and they were very respectful of each other until we came to Judge Hanlon. Judge Hanlon was approximately the 5th person to speak, and she was obviously very upset with what other people had said. Other people had been upset with other panelists, but they spoke about their issues respectfully. Judge Hanlon did not. She basically criticized everybody else and started on a rant. And part of the point that I remember from the rant is when she brought up the rule of thumb law, which is a false myth, but Judge Hanlon presented it as fact. When I found out about her being nominated to the appeals court, I was able to read about her, and I found out that she's deeply involved in domestic violence. And I was surprised to hear someone who apparently has very little knowledge of domestic violence from what I've heard on this panel actually being so involved. And I think that has been a mistake, at least from what I saw at this panel hearing. But what I also saw at this panel hearing is, as I said, everybody was respectful of everybody else's opinion, and everyone was listening to everyone else, with the exception of Judge Hanlon. I was actually surprised to hear that she was even the judge. I didn't know what her position was. The appeals court hears people disagreeing about rulings of lower judges. And in order for the appeals court to work, the judges have to be open to the idea that judges make mistakes. On this day that I saw Judge Hanlon, she made it very clear that she did not believe judges made mistakes. From the people that have supported her today, they've always talked about the people that have appeared before Judge Hanlon as if they have done something wrong, as if the idea that anybody innocent appearing before them is an impossibility. I've dealt with the domestic violence issue, and I know there's a lot of problems, and I'm not trying to blame them on one person, but we have to be open to mistakes being made by the court. And from what I saw at the panel last year, I do not believe that Judge Hanlon has that openness about her, or at least that's not what she showed that one day. And those are the dates that I'm at.
Thank you very much, sir.
It sounds like victim's impact statement. Key thing about Judge Hanlon is I've gotten to know Judge Hanlon for 2 reasons. One is I'm a father's advocate. And very frequently, the domestic violence laws are used to get fathers out of their house, get fathers away from their children, and there is no constitutional protection whatsoever to protect the father. Judge Hanlon has been one of the architects of the system that violates civil rights. If you look at her history, there's been 2 roads to take, and one has been to solve the problem, the other has been to indiscriminately violate men's rights. And that route has been chosen here in Massachusetts, and like an epidemic, it spread from Quincy and Dorchester across the entire United States. And it's very, 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 very frightening. Without so much of a hearing, a man is removed from his house, removed from his children, his wages are garnished, and then if he owns guns, his guns are taken away, and he'll never get them back. Absolutely never get them back. Now, I'll be happy to explain it. I'm not a gun owner. But at the time that the man served with a restraining order, he must immediately vacate. Okay. Now, vacated his family residence. Now, that's probably not a bad thing if there was real cause. But there's no standard of cause whatsoever. A woman just needs to go to court and needs to say, I'm afraid. And judges issue these restraining orders without any concern for the rights of the man involved. He's out and he spends 10 days couch, on his friend's couch. He's been separated from his children. And this is one of the most horrible things about these laws architected by people such as the judge, is it's collateral damage. It's as if the good justifies all the errors and all of the pain it causes. And it assumes that we as fathers have no pain when we're separated from our children. And that pain is enormous. And I deal with this with men every single day. And it's incredibly painful. And we are acceptable collateral damage. If we fought the war in Iraq that way, we would have chosen the nuclear option. Positively unacceptable. I also went to as a father's rights advocate, I counseled a lot of men who have gone before the judge, and they've just simply been issued restraining orders without concern about what the facts were. And the reason is in the system, there is no consequence to a judge for being flipped on appeal. Meaning to have their decision to issue a restraining order flipped on appeal. After the 10-day hearing, after a 10-day period goes by, men have the right to a hearing over the restraining order. Most of the time, I don't know why it's called a hearing because there's no hearing. Within 30 seconds, they're walking away from the bench. It was only through the appeals court in 2005 that we were granted the right to a full evidentiary hearing. Had it not been to the appeals court, we would not have the right to defend ourselves from this. It's really, really frightening. Finally, I just want to clarify one thing that Mr. McKay stated. The rule of thumb is just an example of how much misinformation has been put into the public's eye to create the necessity to override the rights of men in courts against these restraining orders, and the reason for the emotional reason, the evoked emotional response to get people to support bad legislation that doesn't help victims of domestic violence and makes fathers collateral damage. The principle is that there's folklore, and there's a lot of folklore. You'll hear folklore that says that 1 out of 15 children has birth defects, according to the March of Dimes, because of domestic violence. You'll hear things like the rule of thumb that it was legal for a man to beat his wife as long as it was with a switch that was smaller than his thumb. That's been discounted many times. Christina Summers has discounted. Take a look at the literature. It's been discounted and it's not true. I heard the judge use that as a defense for the current domestic violence laws at the New England law. And I also heard her say that the system is never abused. And I think all you have to do, if you really want to make a good decision on Judge Hanlon, and we really can't afford her in the appellate court, because that's the only place that we get any justice. If you want to make a good decision, go out and talk to all the divorced men you know. The men that you have known for 10 and 20 years who are good men, and say the word restraining order. And get them to talk about what it was like to be separated from their children. I spent a year. There was no reason that I couldn't see my daughter. I had joint equal custody. I had physical and regular custody. My ex-wife had a restraining order. My daughter was not included, but I was so afraid of the judges and so afraid of the police that I didn't see my daughter for a year, even though I had the right. But I've seen too many people violated, gone to court, put through hell over these laws that in the end don't address the most serious problem, which is domestic violence, which happens behind closed doors, and requires a real community approach and requires a lot of smart people, not the court of last resort of social services. The courts are not designed for it, and they should stick to actual cases of real abuse, and this program should be moved out of the court. Thank you.
Thank you very much. I have a question. Sure, Councilor Morgan.
You mind if I ask you 3 questions?
No.
So you have a restraining order issued against you, and is there still a pending restraining order against you?
No.
And when you said you think that domestic violence is not designed for the court, what do you mean by that?
We have a set of laws that say that you shouldn't abuse people, that you shouldn't assault people. They're already in place. Okay, we didn't need these laws because essentially they're making social workers out of judges.
So is it your position that judges have no meaningful role to play when a case of domestic violence comes before the court, and that it should belong to some sort of outside agency to deal with?
They have a relevant role to play when there are some facts, when there are people who are willing to testify, when there can be a true evidentiary hearing, but where evidence can be issued and entered.
But you said some things about the use of the restraining order that just aren't true. People don't get an ex parte order without presentation of facts to a judge who makes a decision based on what he or she hears from somebody who's applied for that restraining order. They do it under oath, do they not?
To respectfully disagree with you, there has never been a woman who has been tried for lying in her affidavit.
You can't say that.
There never has been.
You don't know that.
I know that for a fact, because it would be tattooed on.
That has nothing to do with judges, does it?
Yes, it does.
That doesn't the judge is attorney to prosecute somebody for perjury if they think that perjury has been presented to a court.
If women perjure themselves every single day, and it's accepted, judges accept it, there's no punishment whatsoever for that.
Aren't you ignoring the issue of the fact that domestic violence exists and is pervasive? That it has existed for a long time, that for many years it was hidden from the community. And then in the past 25 or 30 years with the domestic violence restraining order, we've created a venue and an opportunity for people to come forward to ask courts for protection from abuse. To the next party order. You're ignoring all of that and making the standard. Well, you know what abuse is, do you not? Under the statute, abuse has been defined as being the equivalent of an assault.
No, it's not.
Well, that's what the court said.
The 2098 statute.
Well, you don't know the law. If you think that abuse is a standard...
I've sat through a lot of hearings.
Well, I'm talking about the law. In order to get a restraining order, a plaintiff has to establish facts that are the equivalent of a criminal assault.
There's no facts.
That's not true.
All our woman has to do is walk in and say...
You keep quiet, please.
All our woman has to do is walk in and say, I'm afraid.
That's nonsense.
I expect to differ with you, and if you would like to line up a special hearing, I will line up. I will line up people, and I will also bring affidavits of absolute farcical stories of what the abuse is.
So you want to throw out the whole domestic violence statute because you think that there are some problems with it, and you want to go back 30 years when we had no statutory mechanism for addressing substance abuse.
The issue with it, and
my question is, you want to throw out the domestic violence restraining order statute in its entirety?
we have plenty of laws on the books to solve the problem.
You can't answer that question.
We have plenty of laws on the books to solve the problem without violating men's rights. Please take the counsel.
I have two questions. One of them was you mentioned that Judge Hanlon was the architect, the judge was the architect of the law. I'm not a lawyer, but I understand the legislature is the architect of the law that are in place. Are you understanding the same thing, or did you mean something else?
She has been very, very active with both the legislature and with working groups on domestic violence that have not considered the civil rights of men and fathers, and that the relationship between between men and fathers, between fathers and their children is very, very important. And they've been willing to throw that under the bus.
And I hear your passion, and I have spoken to many, many fathers, and I hear your frustration. What we're trying to get at is figuring out, where everything belongs. And when you say, or you throw out that Judge Hanlon is the architect of the laws, that's not
She
true.
was one of the architects.
So what law was Judge Hanlon the architect of?
I know that she participated in writing some of the guidelines.
Now, the second thing you mentioned, so can I just ask you again, have you been before Judge Hanlon?
Not me personally, but I have with men who did not, because you don't have counsel in this process, even if you're indigent. You don't have counsel. When a woman, this is a very good point that you bring up. A woman has a domestic violence advocate in her police station. She has a domestic violence officer, usually a woman in her police station. She goes to court, they have a domestic violence restraining order manned by women. When she shows up in court for her 10-day hearing, there is a domestic violence advocate, a woman that stands with her. A man, on the other hand, gets thrown out of his house, separated from his children for the first time. He shows up in court probably for the first time in his life, other than for a traffic ticket. He has no representation whatsoever. He goes before the judge and says, and the judge, next case, restraining order issued.
Well, I don't want to, because as Judge Merrigan said, usually there's a little bit more facts, and I want to cover some of that.
And I talked to 3 men who I've worked with in the Dorchester court. They're afraid to come.
Well, that's my question for now, but I did specifically ask every father that did call me if you have anything, they were calling against either a father or Judge Hanlon, tell me what experience you had with that. And I have yet one, like Mr. McKay was the first person that had any communication with one of the nominees that could speak specifically of his concerns about, but I had no one else come forward. So that's what I want to hear. What
you have to understand is men are tremendously embarrassed. They've been raised all their lives that you do not hit a woman. It is the most heinous crime in men's circles. Now, granted, there are batterers, and I'm not denying that there are batterers, but there is a very, very small percentage. When you accuse a man of that, he doesn't want to talk. I mean, we're not like women. We don't go and talk to our buddies.
Well, there are men's laws and women's laws, and Mr. Patterson, so what we're trying to figure out is what the laws are and how they apply and how Judge Hanlon applies those laws. So I appreciate it.
Well, I guess the difference is, and I'll wrap up with this point, is an advocate is someone who knows, whereas a fanatic is someone who believes. And I think when it comes to domestic violence, and we have too many fanatics, and I think moving the judge to an appellant position would be moving a fanatic there that would block the only recourse that men have from this terrible, terrible law.
Now, real quick, just make a quick statement here, and then when Judge Hanlon, we give her an opportunity, if you could address it. I am probably the most, and you folks, know I'm a strong advocate for children's rights, and my fellow counselors know that. I'm not suggesting that they are not. Domestic violence, there's no question, is a serious problem in Massachusetts. And I just wish all these judges would realize. I understand what Mr. Patterson and some of these other folks may or may not say today. It's pretty hard when you don't see your child. Never mind 10 days, for 2 days, for 3 days, for 4 days. This is a serious problem. And I know domestic violence. I'm not undermining the domestic violence issue. It's serious. But there is no question. Anyone can go into just about any district court, probate court, and get a restraining order. I mean, I talked to these judges off the record. I talked to attorneys. It's a major problem. I understand where you come from, Mr. Patterson. It's tough out there. And I don't know, these judges here, I know you said you have, we've already confirmed you're retired, Judge, but you have 6 kids, grandchildren, and you're proud to say that. But some of these fathers out there who don't see their kids for 2 days, 3 days, you tried. You tried. You're ever sitting in that chair. You tried. It's pretty damn difficult. I understand what you're saying. I'm not sure this really applies because we don't know basically other than this one gentleman had personal experience with Judge Hanlon, but it's an issue that I am very, very passionate about, and I appreciate you coming here today. Thank you. Next we'll hear from Lawrence Watson. I'm sorry?
Can I skip a turn?
Yes. Okay.
Good morning, Judge. Good morning, Counsel. As you know, I spoke here a couple of weeks ago with the other nominee. But just for the record, I'm here on behalf of the Fathers Coalition, which is essentially an advocacy group for men who have problems with restraining orders, who have problems in their divorce, and who have serious problems with their custody issues of the children. And as in last time, I started off and I know you want to keep the focus on the nominee, and I'd like to do that. But as with last time, as I told you, we get hundreds of emails all the time. And I started off by reading a short email to you that I got that morning. I'd like to start with an email this morning that I got from somebody. This is from somebody who is under the restraining order regimen right now. The domestic advocates coach and instruct women what to write on their temporary restraining orders. I have overheard in several courts. I cannot tell you what to write, but the court needs to understand that you are, quote, in fear of harm, end quote, afraid for the safety of you or your child, end quote, all words to that effect. This is the unauthorized practice of law, which is not allowed in the court if the person asking is a man. Try to get the same assistance from the domestic violence advocates, and they will quickly tell you, all right, we are not attorneys and cannot give you legal advice, all words to that effect. This man says, but if I had a sex change, can you help me then? If I had not found a single organization that actually assists men who are victims of domestic violence. When I sought assistance as a victim of domestic violence at the hands of my wife, one domestic violence agency would not open the door and let me in, would only talk to me through the glass. First told me the agency did not service men, and in response to my question as to whether they knew of an agency who did assist male domestic violence victims, the woman responded, and I quote, if you do not leave now, I will call the police. Oh yeah, I was going to say in chat. Another domestic violence agency had a woman come out of the hallway to meet me and, without asking any questions or finding any information from me, said, batteries used the back door, end quote. After explaining that I was the victim, it still took some time to get inside the agency for an intake. At the intake, a woman asked me how long I had been with my, quote, partner. Apparently, males can be domestic violence victims. They just have to be gay, based on the batteries to the back pump. After receiving a safe plan from a domestic violence agency, following that plan by putting together an escape kit, quote, then filing for divorce and leaving the home with my child, I was ordered by a current judge to return the child to my wife. Apparently, only a woman can flee a domestic violence batterer with the kid. Men can run, but they have to leave the kids behind where they belong, with the abuser. Tis a fair court, says this particular email. And this was in response to a comment that the Greater Boston Legal Services, the Volunteer Legal Lawyers Project, and Legal Advocacy Resource Center work with the domestic violence agencies, none of which will assist the males. So getting to Judge Hanlon's court and Dorchester District Court, I went online yesterday and I looked at the statistics for restraining orders in Dorchester Court. This is from 2008. There were 1,138 restraining orders cases in Dorchester District Court. yesterday. Just to give you an overview, overall there were 33,000 cases statewide. Now, Dorchester has a population of 85,000 people. The only courts that were more than Dorchester District Court were Lowell, with a population of 106,000 people, and Springfield, with a population of 151,000 people. So what that says to me, which is in my gut I already knew, which was that there's probably the right word, an eagerness, a tendency to issue restraining orders in a court such as Dorchester District Court. So I would say that on behalf of the Fatherhood Coalition, we don't think that, as Mr. Jackson said, we don't believe that the elevating of Judge Hanlon to the appellate court would be a wise decision, because as was brought out, when there are problems, the only recourse has been in the appellate court. And to get to a couple of points that Councilor Merriman raised about perjury, the anti-SLAPP law was ruled as a reason not to consider any charge of perjury in a domestic violence law. They rejected outright. They ruled that in a case that came before us, they said if someone is bringing a charge under the 209A as a perjury charge, they said you can't do that because it violates the anti-SLAPP law. So just to bring that up to you, you can ask me that later if you want more questions. Now, regarding some of the things Judge Hanlon has said in the past, there's a book by a man named Richard Davis, Domestic Violence Facts and Fallacies. And Richard Davis is a strong supporter of domestic violence laws. In fact, he wants to incarcerate people just on the accusation of domestic violence. He doesn't want to let them out when they've been accused. So Judge Hanlon in this quote is quoted as stating in this book, the system is not equipped to do that is incarcerate people just on the accusation. And they shouldn't be, frankly. This is Judge Hanlon, which is a reasonable thing to say. This person, Mr. Davis, says, if the criminal justice system is not so equipped, why is it that Judge Hanlon and the courts continue to issue restraining orders in Massachusetts at the rate of one every 2 minutes? They're given out like candy, has been the often quote for restraining orders. And so if I remember correctly, I believe that Judge Hanlon has stated in the past something along that line, that they shouldn't be incarcerated, and the purpose of the restraining order is to punish the offender. But then the question is, why are men and fathers being punished without a presumptive right to a discovery of evidence? There's an evidentiary hearing, but there's no right to discover evidence, and without any kind of jury trial, as I've heard to the counsel before. So I would say that the trend that this is an anti-male statute is pretty clear. In a book by Elizabeth Mulroy called New Uprooted in 1992, Judge Hanlon is quoted as saying, there are more shelters for animals than there are for battered women. And a shelter is a very short-term solution, especially for a woman with children. Nothing about a man with children. We tolerate a society which is profoundly sexist. The idea is sexist against women, but not against men, in violent homes and violent neighborhoods. Many of the men against whom I issue restraining orders have never seen anyone solve a problem in a non-violent way. So when I read this, I read someone who's speaking of the restraining orders coming from a female perspective and not really thinking at all of a male perspective. So I'd like to suggest that the council, when the judge has a chance to make a presentation and ask questions, that they consider some of the following questions. As a proponent of the VAWA, the Violence Against Women Act, the underlying premise of which is that men are inherently violent, why does she believe that men are this way? Why does she believe that men are inherently violent? And if not, why support the Violence Against Women Act? Why should any man who comes before her believe that he will get a fair shake when her domestic violence program is based on the idea that men are, in fact, inherently violent? Why does she believe that domestic violence charge results in the loss of one's children, homes, finances, and possible employment, does not deserve the protection of discovery procedures in a jury trial? The results of it are so onerous that they should have these protections. Has the judge ever taken any steps to help men who are removed from their homes as a result of domestic violence charge? As Mr. Patterson said, the domestic violence accusation removed men immediately before the hearing 10 days later. Has there been any steps in the fatherhood program that this gentleman raised to protect those men, to find housing for them, to keep them with their children? And who brings more domestic violence complaints, men or women? Who are more complaints granted to, men or women, in Dorchester District Court? I would be interested in hearing the answer to that question. And I guess close to the final end, does she believe that there are false accusations of domestic violence? And if so, what percentage, and what has she done to deal with it? So a lot of questions, I think there's a lot of meat within those questions, and I'll invite any questions.
Councilman?
There's something that really strikes me is you've been here now on behalf of the Fatherhood Coalition, and there's something that strikes me is sexist about your decision. In being here, in February, we had a prosecutor up for judicial nomination who was a man from the Cape Cod District Attorney's Office. He had been involved in domestic violence prosecution for years and years. He was as renowned probably as anybody, from what I could understand. And yet you and people from your coalition never came to speak about any similar concerns about him. And you only showed up when there have been two women. And it strikes me that your approach is sexist. And I don't think that you're doing anything but asking us to stereotype women in the way we heard you complain about the way men are stereotyped.
Would you like me to respond to that?
Yeah.
Well, I would say that
here in February.
Well,
I
would say that, as you know, since last summer I've been here, and I've written you on many occasions about these problems. I did not know about that particular. I knew there was a person of that name, but I did not have the time to come to that hearing, and I did not have the energy to speak to other people or time to speak to other people. But at the same time, I would throw the question back to you. At that hearing, when this person was in front of you, did you ask these questions of that person? Because I have given all of the counselors here a lot of information about these particular issues. And so as a counsel, did you take the issues that I have presented to you before seriously enough to raise them at that issue?
No, I'm not going to answer your question. But I'm looking at your webpage, and you use your webpage to communicate about hearings, and it says urgent opposition to the appeals court judge's appointment. Urgent. You are needed to stand in opposition to the appointment of Judge Cindy Hamlin. And let me just ask you this. As a female, it spells her name S-Y-D-N-Y. On your webpage, you spell it S-I-D-N-Y, and that's not a tongue-in-cheek sort of aspect of something you're trying to make a point about, is it?
I think you're grasping at straws there.
Well, I don't know.
Typographical error is not something that I'm going to claim responsibility for.
But in any case, you certainly have a vehicle and a mechanism and a venue. It generates support when you want to do so. And you were nowhere to be found, or anybody else in your organization, when we had a male before us who had a very strong domestic violence record.
Well, I would say that if you were to bring that person forward again and you have a chance, now that we know more about it, we would certainly be here.
But why didn't you know that?
I told you I did not know about it.
Well, so why didn't anybody else know?
You have to have
fact that there was no affirmative effort to know about a man who had a similar set of background credentials as the two women. It seems to me a false explanation for why your position here is reflecting some sort of sexist approach to these nominees.
Well, again, I think we're not, as I said before, we're a volunteer organization, so we don't have all the resources to be on top of all these things all the time. But in regards to the two nominees that you're comparing this man to, whose name I don't remember right now, Judge Hamlin is well known to everyone who's concerned with restraining orders because of her participation in the 3 national pilot programs. I don't believe this man has ever, I don't know if you know the man's name we're talking about, but I don't believe he's ever participated in a national program. So I would say that there's no question that Judge Hamlin is on the top of the radar screen in terms of her activity in these groups. restraining order business.
Council Farrell?
I guess what I'd like to say is that we've been to so many of these hearings, so we've spoken, your emails, all of that, and you do have issues. I mean, there's no doubt. I mean, I hear the passion, I hear the injustice that you feel. I guess I wonder at this point if some of that, could be better placed dealing with the legislature in terms of some of the language that you want to see in that. I think we would all sit here and we'd be lying if we didn't say domestic violence nationwide is not an issue. It is. We read about it, we hear about it, we know it's out there. To say someone shouldn't be appointed because they've been a part of something that's nationally known and try to help with that. Also, statistics that I have, and not today, but another day, if you'd like to bring them to my attention or email them to me, 84% of all domestic violence is committed by male. I'm not saying anything, I'm just saying what the statistics I have been presented with. So I don't have them here either, so I'm sure you might, so whatever you have. Just like breast cancer, we mostly think of it as a women's disease, while there is a percentage of men very seriously dealing with that issue. So that's probably why we hear more about it, because the statistics show more women. But I don't want to get into a male or female thing. I already discussed it with White. We didn't come up for the other gentleman. But for me, that's neither here nor there at this point. I would like to offer my suggestion, and I've told you, the assistance in getting it to where I think it best belongs. If the legislation is there, if the rules are there for these judges to look at these issues on a case-by-case basis, I think the one thing that I've heard today is you say, and your group says, that they just walk up and go, I'm afraid. And the judge goes, okay, here you go, restraining order. And I'm not going to deny that more women get them than men. That's the numbers are there. But I tend to think that, or I would hope, when I speak to Judge Hanlon and others, that a lot more effort is putting into determining whether the restraining order should be granted, number one. And if not, then we're going to look at those laws. And I direct you and your people and the passion with everyone who calls me have the same sentence to me, which was, I don't want to see this judge, she's dangerous, she's unfair. I go, well, what do you know about it? I don't, I just know she's unfair. And I was like, gosh, I hear you, you feel, and I feel that you have a real issue, but I just think you'd be best placed, in addition to coming here as much as you want, it's a public hearing, also taking it to the legislative end and sitting down and figuring out how measures can be put in place. Because it is a real issue, domestic violence. It's out there, and it's serious. But how do we do it so that some of these injustices are not happening? That's all I have to say.
May I comment back? Well, just to, the other day at one of our local meetings, a younger man was younger than I am, and he said, well, when I was a boy, my father used to beat my mother up. And he was sort of supportive of domestic violence regime. But he said that the reason that he was that his father was allowed to do that was because the police came and they didn't arrest his father. They just took his father down the street and talked to him. So the problem was really that, of course, human nature is such that there's conflict, and in marriages there's conflict all the time. The problem excuse me? No, what I'm saying is the problem could have been solved with the existing laws, because the police were there and they should have arrested his father and taken him for an assault. That was clearly something that should have been done with that young man. So the point that we try to make from our position now is that, as Mr. Patterson said, there are laws in place that deal with assault and battery. When there's real assault and battery, people should be held accountable for it. What we see from all the people that we talk to is many men are accused of domestic abuse, which leads to a criminal charge if they inadvertently make contact, inadvertently or deliberately make contact with the other partner in the future. But it becomes a criminal thing. And it should, right from the beginning, if it's going to be a serious result of a criminal charge, and loss of children, loss of home, loss of finances, there should be more of a structure within the court system that makes that charge reviewed under the judicial proceedings that are there, such as discovery of evidence, such as the jury trial. I mean, people should not lose all these things without having some kind of review by their peers. It's part of the Constitution. We offer a right to a jury trial. I mean, as you said, domestic violence is obvious. Violence is part of the human nature. We we don't deny that, but we should look at it in the fact that real domestic violence is real assault, and that should be dealt with. But not under this regime.
Thank you, Councilor Young Manning. Christina, you have a question of...
Yes, hi. Okay, let's talk about the legislative structure and the judge. You want the judge to handle things differently than what the legislature says it should be handled, how the legislature says it should be handled?
Yeah, as I said in the initial...
Okay, this is a yes or no question. It really is. Do you want this judge or every other judge to deal with restraining order cases differently than how they're written in the law regarding discovery, due process, and all of that stuff?
It's not a yes or no question, because in the administrative procedures, they have the right to allow discovery. But it's not a presumptive right.
Okay.
But they should allow discovery of evidence for these kids, because the results, the effects are so onerous on men.
Okay, so let's say that that's true, that those are there. Are you saying that this particular judge has exercised his discretion against allowing discovery in a vast majority of cases, or 50% of the cases, or 2% of the cases?
I don't know. I haven't researched it, so I don't know the answer.
Okay.
But I would say that my guess would be yes.
Oh, your guess would be yes. Okay, I'm going to write that yes. So, I think it's important. Everything you're saying is important. It has value. You have every right to come back here, and your group has every right to come back here. Your group has been here many other times, including for male nominees. Perhaps not during this past, not past this past 2-year term, that's possible. And maybe not on the domestic violence issue, that's possible also. I believe that your group has been here for custody matters regarding prior nominees. But be that as it may. My background is as a domestic violence attorney on behalf of people who have claimed abuse. I've also defended people who've been falsely accused. I think that you have every right to be here. You're welcome to come back. I don't think it's an appropriate use of counselor's question time to abuse members of the public who come here with name calling. And I don't agree with everything you have to say, but I do believe you have the right to come here and say it. And I don't want the way that you're being treated today to discourage other members of the public from coming forward. Don't attack the people who come on behalf of nominees, and I don't think that we should attack the people who come to oppose nominees. With respect to the anti-SLAPP statute preventing perjury charges, what case, is that a case?
It is a case. I can't remember the name of the case off the top of my head. It may have been McClannon was one of the parties. But there was this case, and it's well known among people who are subject to these false allegations that if they go through the whole process of appeal, that when it gets to the SJC will say, this is under the SLAPP, you cannot bring this to anti-SLAPP.
Regarding the 1,100 or so, I think I was going to reduce restraining orders issued that were issued out of the Dorchester District Court, and was that her court? Was that under Judge Hanlon?
2008.
Or under all the judges in?
It's just from the website, it's just the Dorchester Court.
Okay, all right. So the other thing that I wanted to say is, did you see how many were applied for versus how many were issued?
No, I don't have that information.
Okay.
But these are active cases. So I assume that they're all active.
That information is not available.
Okay.
You cannot go, it's been legislated. We used to do it. We used to go and do research in the courts, but the legislature quickly passed the law to prevent us from getting those numbers.
Okay. So just to be clear, because I don't want that information. I understand the third highest issuance of restraining orders in the state basically is what you said. According to the research that you found, I'm not holding you to it, but I just don't want that number to be misunderstood. It may be the third highest in the state, but it could have been 100,000 restraining orders applied for in Georgia. They all could have been in Judge Hanlon's court, or none of them could have been in Judge
Yes, I only said the information I had. But my point in saying is that with the population of about 85,000, 90,000, there were other cities, Springfield and Lowell, that had more, but not much more. And so compared to the population, it seemed to be a very high number of people.
Right, except that it is Dorchester, and the violence level in the inner city of Dorchester is, you have to factor that in.
Sure, I don't think Lowell is
I think
considered
there's
as...
probably more murders in Boston than there are in Lowell.
I don't know.
I would think there were probably more. Or in Springfield. And just so that I'm clear, with respect to the organized effort against Judge Hanlon's appointment today, is it my understanding that you believe that she's kind of a policymaker with regard to the Violence Against Women Act, a policymaker with regard to the domestic violence statutory framework, the 209A framework? Is she a leader in this field? Do you see her as a poster child for this movement of what you see is wrong with the 209A order system? Is that why you're here?
Yes, exactly.
Specifically for her?
Yes.
Just to make sure that, in the future, and I think just as, my 2 cents, your comments in general as a group are probably going to be more valuable when you come forward specifically about a specific person like you have today, as opposed to, I believe the last time you came, you didn't have anything specific to say about the nominee. It was more of a general idea of if this particular, I think somebody's already pointed out, because you worked in the domestic violence unit of a district attorney's office, therefore, you believe that she's part of this overarching problem.
Well, there was more than that. She was also part of the domestic violence. She was a leader of the domestic violence task force in Western Massachusetts.
Okay.
So there was more than just being in the court. There was also the extra judicial activity.
Okay, so both Judge Hanlon and the other nominee we're talking about, which I believe is Lawrence Clark?
Yes.
Is that the other nominee? Both of them held themselves out in this field.
As proponents of the domestic violence regime.
As it is. I understand. Okay, thanks very much, Counselor.
Thank you very much.
Wait, no question.
Okay, just one second.
Okay, wait a second.
Sure, quick question. When you sit down, not right now, I know you have the list with you. Could I just see what all of them in the best first?
Sure. Yeah, I have a whole statement.
Before we have Councilor Devaney, do you have any questions?
I did.
Okay, well, do you still have it?
First of all, I empathize with your group, and Councilor Manning's not here, but I did want to make a point of information that we did have a speaker that had specific comments to the nominee. I take this all in consideration, believe me, because I am concerned, and I don't think there's anyone here that hasn't seen a man that has been unfairly treated. And that's not to say that men go bad or even murder. One of the reasons I'm here, that I ran for this office, was that I had a friend that was murdered and was battered a number of times in the court. But I know the other side, and I know I have a friend right now who's a friend of mine and my late husband, and wonderful father, wonderful husband, and his wife found the boyfriend, and so he has no chance of getting custody of the boys. And he's a wonderful man, wonderful person. So I understand, and I know that women lie, and they're not all truthful. Men are not all truthful. And so I'm not a lawyer. I'm not, going to go to, to point to different trials. But I will say that, I want to apologize for how you've been treated here, because it is disrespectful, and I welcome anyone from the public to speak for or against, because that's what a democracy is about. And the previous speaker said that there are people that will not come before us. They're elected. They're afraid. And this is a sample of why. So I want to apologize for that. And I will take everything in consideration. Councilor Manning stepped out. I want to say, as a point of information, before you came, we had a speaker who talked directly about his experience before by nominee.
How much?
Okay. So I will take it all into consideration. And agree with opinions of the council. Thank you.
Thank you very much. Thank you. Next, I'm going to hear from Lawrence Watson, and I just want everyone to understand that the Lieutenant Governor may come in at any moment. At that point, we will recess, and you folks can all stay in the room. We should resume, and once we do recess, we should resume the hearing, I'd say approximately 15 minutes later. So you're all welcome to stay here for the hearing. Thank you, and I'm sorry I took so long. Mr. Watson.
Okay, I've come to the opposition of the appointment being handled to the appeals court. Many things I'll say will report what Mr. Patterson said. This is from personal experience with more than